Petitioner's motion, this is Jamie versus Jonathan. Petitioner's motion regarding the respondent's intentional evasion of service, request for alternative service or other appropriate relief, and request for expedited consideration. This was filed July 15th. I don't know if it has a decision yet. You guys in the chat know this better than I do. If you know there is, please share it. If there isn't, seriously, court. Why do the court always take this long? Either way, background. On June 24th, petitioner filed a motion for contempt together with supporting exhibits and proposed modified no contact order, which we just read. The court issued a summons directing respondent to answer the motion within the time prescribed by law. Petitioner retained a certified Florida Special Process Service to personally serve the respondent with the summons and motion for contempt after learning that out-of-state personal service would need to be arranged privately. 2. Respondent's intentional evasion of service. Attached as Exhibit A is the affidavit of non-service executed by appointed Florida Special Process Server, describing 3 separate attempts to personally serve respondent. 5 according to affidavit. 2 separate attempts were made on June 27th. Respondent failed to answer despite his vehicle being present. A 3rd attempt was made on July 2nd. Dave says, we're planning a trip to Cuba. Are you in? Nope. Sorry. Not that I don't want to go to Cuba because of my interest in cigars. I would go so far into debt buying cigars in Cuba. So it's pure self-preservation. Also, Cuba at the moment don't have much electricity. But thank you for the offer. Thank you for the offer. Access to the front entrance had been intentionally obstructed by a newly erected makeshift private property no trespassing sign with ropes stretched across the entrance, preventing the process service from legally accessing the residence. Yeah, we went through this about an hour ago. A private process server are not allowed to enter through these. A police officer can, but if he doesn't answer the door, then he doesn't answer the door. Photographs taken by the process server accurately depict the physical obstruction placed across the entrance. The process server additionally posted written notice of the pending legal proceedings at the respondent's residence, attempted telephone contact, and sent a text message advising respondent that legal documents were awaiting service. No response was received. I specifically recall one of the JLR cockgobblers telling me, JLR, he is known for following the law. Really? 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 3. Respondent had actual knowledge. Petitioner believes respondent had actual knowledge of the pending proceedings. During the first two service attempts, respondent was conducting an 8-hour public live stream broadcast from inside the jointly owned residence while failing to answer the door. Attached as Exhibit B are screenshots from respondent's publicly available YouTube livestream corroborating petitioner's assertion that respondent was physically present inside the jointly owned residence during the Florida Special Process Service 2 separate attempts to effect personal service on June 27th. 11. The process server likewise advised respondent by posted notice, telephone call, and text messages that legal documents awaited service. Respondent nevertheless took no action to accept service or communicate with the process server. If JLR has representation, there's always an option to ask that representation, that attorney, will you accept service on JLR's behalf? That's a choice. I don't know if they have done it yet, but it's a choice. Respondents continuing conduct following filing of the motion. Since petitioner's motion for contempt was filed, respondent has continued engaging in the same course of conduct described in that motion. Among other things, Respondent has continued publicly using petitioner's original creative works, including thumbnails created by petitioner during the parties' relationship, despite petitioner's repeated objections and despite those acts already being specifically identified within the pending motion for contempt. Yeah, we went through that, and I do personally believe this is not the venue for it. Rather than stopping the conduct described in petitioner's motion for contempt, Respondent has continued live streaming while publicly displaying petitioner's original thumbnail designs for commercial gain, including multiple consecutive days during the week immediately preceding this filing. Now that can be used as an indication for the court that that was actively used to show contempt. Ownership in itself, harder to show, but the use of it, that can be an indication in what we call totality of the circumstances. Petitioner has observed third parties publicly claiming that the text messages attached to petitioner's motion for contempt are quote-unquote fake. Petitioner believes this assertion originated with Respondent because Respondent still possesses the original Telegram communications and has personal knowledge of their authenticity. Those communications remain preserved as evidence in the pending criminal domestic violence case against him in Pasco County, Florida. Petitioner is also aware of continuing reports that the individuals who publicly discuss Respondent's criminal cases has been subjected to harassment, threatening communications, intimidation, and retaliatory conduct by Respondent and his associates. Petitioner offers this information to demonstrate that the overall pattern of conduct described in the motion for contempt has not ceased. And then impact on petitioner. We already been through that in the other filing. Wait, who's saying that he is not? Oh, Stella, it's not against the law to not answering your door. No. She's correct. It's not illegal to not answering the door. But to claim not being aware about attempts to service, that's shady. And here's the thing. The amount of times this have been publicly discussed and he's been tagged on X in replies to his ex, he knows there are attempts of service. So if he actually wasn't avoiding it, then he can have his attorney contact Magnolia's attorney and accept the service. So yeah, I would say he's avoiding service. Now, at some point, the facts has to speak for themselves. And I've said this before, JLR is very, very entertaining. Very, very entertaining. I understand that he has this large following that he has, but at some point, you have to acknowledge that fact speaks for itself. Not allegations, but facts like this. Is he avoiding service or not? Yeah, we can actually conclude he is actively avoiding service, especially since he put up no trespassing and roped his gate. That tells me that he knew this was a private process server, and he also knows that if he ropes the gate shut, a private process service can't go through it. That goes to intent. Respondent's unilateral alteration of jointly owned property. Respondent says also unilaterally altered jointly owned real property by erecting a makeshift no trespassing barrier across the entrance gate consists of ropes and signage without petitioner's knowledge or consent. Now here, that's actually a good point. So even though they weren't married and did the mistake of owning property and stuff together while not married, if they are separating, you really can't do shit to the property without consent. If it's a jointly owned property, both parties has to agree on any alterations, renovations. I mean, it's not even a it's not even a question of that. Really is, once there's a separation, which it is, you can't alter anything about the property. You can what you call it, not falling into despair, but you can't substantially alter it. Nick, isn't the burden placed on her to have the process server deliver the court documents to his lawyer? They can only contact the lawyer to ask him to accept the service. If the lawyer says no, they can't use the lawyer for that. No. Why would you expect it to be his obligation? No, your argument was that he wasn't avoiding it. That was your argument. He is not doing anything evasive about being served. And I brought you the argument, he roped the gate shut with no trespassing, making it impossible for a private process server to enter. That is avoiding service. At one point, you have to accept the truth here. But thank you. I mean, folks, I don't mind being challenged. I don't mind criticism. Just don't troll me. Stella here, she doesn't troll. She asks important questions that I feel obligated to try to answer. So Stella, thank you for asking me tough questions. Thank you. Petitioner objects to these unilateral alterations. The entrance barrier materially changes the appearance of jointly owned property, creates an unprofessional and neglected appearance, and is inconsistent with preserving the property while ownership remains unresolved. Yeah, that's what we just went through. The improvised barrier creates the appearance that the property is abandoned, neglected, or otherwise subject to unusual access restrictions. Petitioner is concerned that such unauthorized alterations may negatively affect the property's appearance, marketability, or perceived value, while both parties continue to hold ownership interests. Petitioner did not authorize the installation of these barriers, ropes, or signage, and has never consented to respondent making unilateral modifications affecting the appearance or access to jointly owned property. This here should be a separate filing as well as underlying facts for the court. Respondent's failure to engage in court-authorized settlement discussions. The existing no-contact order expressly authorizes communications through legal counsel concerning restitution, settlement, and the division or disposition of jointly owned real and personal property. More than 6 months has elapsed since the parties separated following respondent's alleged assault upon petitioner on December 25th. During that time, respondent has made no effort to initiate settlement discussions, propose a division of the parties' jointly owned assets, address restitution, or otherwise resolve the financial issues arising for the parties' separation. What I'm missing here are examples from her in this. What I'm missing in this part, it might show later, I don't know. This is the first time I've read this. But in here, it would certainly help if Magnolia could show that she is trying. In an effort to resolve these matters without additional litigation, petitioner transmitted a proposal. Oh, here it is. I should have just kept reading. In an effort to resolve these matters without additional litigation, petitioner transmitted a proposed separation and restitution agreement to the respondent's attorney of record in these proceedings for review and consideration. Neither respondent nor respondent's attorney provided any acknowledgement of receipt, response, counter-proposal, request for clarification, or other communication concerning petitioner's proposed agreement. There it is. I should have just kept reading. As a result, respondent continues to exercise exclusive possession and control over jointly owned real and personal property while declining to participate in the only method of communication specifically authorized by the court's order for resolving such matters. Petitioner remains a co-owner of the party's residence and other jointly titled assets and has received neither a proposed buyout nor any meaningful effort to resolve the parties' respective property interests. Petitioner respectfully submits that respondent's refusal to engage in the court-authorized process for resolving property and restitution issue, while simultaneously continuing to exercise unilateral control over jointly owned assets, further demonstrates the necessity of the relief requested in petitioner's motions for contempt and the proposed modified no-contact order. These continuing events further demonstrate the necessity of the relief requested in petitioner's motion for contempt and support adoption of petitioner's updated proposal modified no-contact order attached as Exhibit D. Request for relief. Petitioner respectfully requests that this court accept and file the accompanying affidavit of non-service and supporting exhibits as evidence of respondent's intentional efforts to evade personal service of the summons and motion for contempt. Take judicial notice that respondent has been made aware of these proceedings, yet has engaged in deliberate pattern of avoiding personal service despite repeated attempts by petitioner's duly retained Florida Special Process Server. Consider respondent's continuing post-filing conduct, including continued public use of petitioner's creative work, continued unilateral control over jointly owned property, refusal to participate in court-authorized settlement discussions through counsel, and other conduct alleged to violate the existing non-contact order. Determined that respondent's ongoing conduct demonstrated continued disregard for authority of this court and for the obligations imposed by the existing no-contact order. Grant petitioner's motion for contempt and impose such sanctions as the court deems just and proper. Adopt petitioner's previously submitted proposed modified no-contact order, replacing the existing mutual provisions with an order applicable solely to respondent as requested in petitioner's original motion for contempt. Grant such other and further relief as this court deems equitable, just, and proper under the circumstances. Respectively submitted, Jamie. And here is the affidavit. Affidavit of non-service, return of non-service. Before me, the undersigned authority personally appeared in the process server named below, who, being first duly sworn, deposes and states that there are special process server appointed by the Sheriff of Pasco County, Florida, or otherwise authorized under Florida law, and that the following facts regarding the attempted service of process upon Jonathan Riches are true and accurate. On June 27th, I made 2 separate attempts to execute service of process on Jonathan Richards at the subject's address. First at 4:50 p.m. and subsequently at 5:35 p.m. On both occasions, there was no response at the door despite the target's vehicle, a white Kia, being parked in the driveway. On July 2nd at 5:20 p.m., I attempted a third service but was unable to gain physical access to the front door due to an artificial blockage and a posted private property no trespassing sign. The entrance was obstructed by a white decorative wrought iron gate anchored between 2 stucco pillars with a trespass warning affixed on the upper left portion of the gate and a matching wrought iron table pushed flush against the rear. Furthermore, a bright yellow cord was wrapped across the entryway, tied to the right pillar, stretched horizontally across the gate, and staked into the ground with additional diagonal strands, creating a makeshift physical barrier. Pursuant to Pasco County Sheriff appointing authority restrictions, process servers are strictly prohibited from crossing a legally posted no trespass sign, rendering the door inaccessible. Due to the physical barriers, I secured a formal note to the front of the gate advising the respondent of the pending legal process and providing my direct contact information. To date, no response have been received. Supplemental skip tracing and communication attempts were made via telephone. The initial call went directly to voicemail on the first ring, followed by a pre-recorded message indicating that the mailbox was full and unable to accept new messages. A subsequent text message was transmitted to the same number, explicitly advising the respondent of the legal documents awaiting service. No communication or acknowledgement has been received from the respondent regarding the posted notice or electronic correspondence, and the process is returned as non-service. Page 2, under the penalties of perjury, blah, blah, blah. And oh, this is funny. This is funny. Now, what I mean with evading service here is that JLR, with this, acknowledged that a process service had been at his place. He countered in avoiding being served with raising this gate and putting. Is that a clothing line or whatever it is? Oh, that's so funny. So yeah, in my opinion, this shows he's actively avoiding service, because the gate wasn't there on the 2 first attempts. It was there on the 3rd attempt. Now, I have to say this. On the few cases I've seen of avoiding process servers, usually it takes more than 3 attempts. Usually. I've seen cases where they tried for every day for weeks on end before the court allowed them to use that. But I believe that was in New York. Florida might be different in that. It's up to the court to decide. It's up to the court. Let's see. Anything else here? No, it's just another. And yeah, Exhibit B, screenshot from, because he was live streaming at the time. Yeah. And other screenshots. Geez, 10-hour live streams. That's impressive. I have a few of those myself during the Young Thug RICO trial. That was interesting. I covered the Young Thug RICO trial for 2.5 years. That was... So, ask me about Georgia RICO. So, yeah. All right. That was that. What else do I have here? No, that was that. Was I sent anything? No, that now we seem to have gone through the materials regarding the contempt and the service against JLR regarding that contempt. This is interesting. Now, in my opinion, as you know, I support justice for Magnolia. But that I will not throw away my analysis or divert my analysis to be just pro Magnolia. I see some problems with some aspects of this motion, especially regarding the supposed ownership of the material that he uses in his live stream, like thumbnails and such. But it's up to the court to decide. It is up to the court to decide. And this latest, the service thingies, was July 15th, so it is over a month ago. And to my knowledge, the court haven't decided yet. The court haven't decided yet. And folks, I should have said this in the beginning. Do not contact either party. Do not. Don't be an asshole. Do not contact Magnolia. Do not directly contact JLR. Commentaries on X and commentaries online, that's free speech, but do not contact them directly. This is a criminal matter between two parties. That has to be done through the court and through the justice system.